All right. Good morning. Good morning. How's everybody doing?
Great,
Great.
thank you.
Thanks for having
Good,
us.
good. We are tuned in here. My name is Chris Carr. I'm with Black Land Ownership. We got the sweatshirts here. And we're doing a new series called Just for My People, the Black Land Ownership version. And I'm speaking with architects, lawyers, planners, activists, um, farmers, developers, and trying to centralize information when it comes to land ownership, and specifically looking at how marginalized folks have been dispossessed or had difficulty gaining access. And today we have two special guests. Would you like to introduce yourself, starting with Diana?
Sure, thank you, Christoph. I appreciate it. My name's Diana Norris. I'm a Virginia attorney. I currently work at the Land Trust Alliance. I'm the Associate Director of Conservation Defense, and I really appreciate this opportunity to be with you today.
Thank you. And Chris?
Sure. I'm Chris Pickler. I'm a South Carolina licensed attorney, and I have just a passion for some of the issues we'll be talking about today, and appreciate your having us here. My day job is actually as a real estate attorney at Lowe's companies, Lowe's Home Improvement, but I am on the board of directors for the Land Trust Alliance. As well as incoming board of director for the Center for Heirs Property Preservation in Charleston, South Carolina.
Okay. Now, in reverse order, so starting with Chris this time, can you give me a little background of yourself? Like, what your attachment to the land is and how that then became intertwined with the legal profession or your kind of community service work, and how we got from as a youth to where you are now.
Yeah, no, certainly, Christoph, and again, thanks for this opportunity. It's a privilege to be here and to talk about this. So I grew up in the rural southeastern North Carolina and South Carolina. My dad at the time was in the textile industry, and so we moved around kind of textile farming town to kind of small rural town to small rural town, but kind of the constant for me was that landscape that you see in the Eastern Carolinas. It was the tobacco fields. It was down around the coast. It was the salt marsh, kind of all of that, just rural, really undeveloped landscape for the most part. And I guess when I was growing up in the 80s, started seeing some of the coastal development that really took off along our coastlines. And of course, as we know, that impacts heirs property owners and any rural landowners. But that got me interested actually in environmental law. And so through a series of, undergrad, grad school, law school, kind of went down that path. And, my interest actually kind of changed a little bit more into the real estate side because of the law firms I was with. And, but my interest in conservation was always there. And so that was the volunteer side of what I did outside of it. And I think that evolved. 2005, when I was practicing law in Charleston, that's when the Center for Heirs Property started, and that's really when I became aware of this whole concept of heirs property and what it was and how it impacted minority communities, particularly Black communities, disproportionately. And that kind of planted a seed that I would come back to in my volunteering with conservation and with my work, because I think with dealing with real estate, it tends to be a little, it's not as personal because you're not really interacting with individuals, you're interacting with companies, for example, or whatever. And so I think as I started, as I was sitting around in some of the conservation meetings, I just little light bulbs started going off in discussions I was fortunate to have with folks. Kind of steered me, and I think it really just led me back to the heirs property work, because that's so fundamental to the impact it has on individuals' lives, families' lives who want to keep land in their family and not lose it for development or other purposes. So that's kind of, I guess, a nutshell. I can certainly go a little bit more with it, but it's that love of the rural land. And what I would say just to that is when Jenny Stevens, the director of the center, invited me to join their board, we were having some discussions, and she said, "Welcome home." And I think that was so powerful to me because that took me back to kind of the sense of community and all that I had growing up. Particularly the town I was in the PD region of South Carolina, was majority Black. We had friends with people of all skin colors. You know, that was just the normal, and I think in society moving around, you know, people may bubble off into their professional or other settings. And through, I think, more concerted effort in volunteering and all, you know, it became to feel more normal as to what community meant. And so when she said "welcome home," that pretty much said it all, you know. And I think the Land Trust Alliance, I'm just so excited of its interest in this topic, you know, and we can certainly go, you know, more into that later. But because I think, you know, it's an area of local land conservation ownership that has historically maybe been overlooked. So with that,
Okay.
I'll
It's refreshing to see, because you know, oftentimes people can take on a rather cynical view of attorneys or even whatever profession, and not recognize that there's actual attachment. So I'm glad I have two people on here who are passionate about this. Diana, can you give me a little bit of background on yourself and how you're tied to this subject?
No problem. Sure. I grew up in the Washington, D.C. area, and after law school, I moved out to the countryside of Virginia, where I went into a very small practice. We did every type of law possible in a small community and really tried to serve our clients. So I was working in trust and estates or real estate, nonprofit law, a variety, obviously. I then moved into in-house counsel at a land trust called the Piedmont Environmental Council out in Warrenton, Virginia, where they promote and advocate for land conservation and easements. And that's where I came across an article one day in my Virginia Bar magazine about heirs property. And I really had no understanding about the complexity of that issue. And I started to educate myself on heirs property. And I thought, wait, this is such a really interesting intersect between property law and trust and estates and environmental justice and racial justice, so many things converging that I thought I need to know more. I need to really educate myself. So I reached out to the authors of the article and really the leads on the subject in Virginia, the Black Family Land Trust. And I said, how can I help? And through a conversation, it just sort of developed, and it ended up that legislation was being proposed in Virginia for the second time to address some of the issues with heirs property. And through my legal work, I eventually was asked to serve on a work group to have that legislation passed in Virginia. And I'm happy to say it was passed last year with a unanimous vote, which is pretty rare in the Virginia legislature. So, but really, it was due to the Black Family Land Trust and all its efforts to get that enacted. And so now I'm, as I mentioned, working at the Land Trust Alliance and Conservation Defense. And this is an area that we are trying to really explore our role as a land trust advocate to determine where we fall in this conversation. And I do want to mention that the Land Trust Alliance is putting together a curriculum about public and private land conservation, the history of public and private land conservation. And included in that curriculum has to be and will be discussions about heirs property and constructive dispossession of land. And so I really look forward. I am certainly not an expert. I am a student. I continue to learn about these issues, but it's really, as Chris mentioned, there are sides of it that are academic, that are legal, but also a very, very personal layer. We're talking about people's homes and their histories. And I'm just really excited to be a part of it.
Yeah, I mean, this topic is so vast. When I first started trying to learn more about the history of land ownership in the United States, and specifically looking at how that affected indigenous folks and people of African descent, one of my main obstacles was how to centralize information. There's stuff over here, like if you are looking at not-for-profit organizations, they have certain goals, agendas, and orientations. If I'm looking at like historical data, if I'm looking at legislation, if I'm looking at some of the political movements and ideas, and it's so overwhelming. And so I can see how we'd all be students. And that was just in me trying to understand how people were marginalized. I then started learning about heirs laws, partition sales, things that dispossess people. And I was like, oh, it's not just not being able to get it. It's we lose what we had. And so can you all maybe walk me through some of the definitions, some of the terms when it comes to heirs law or conservation vocabulary, so that when we get into the real discussion, we have an awareness of what we're all talking about?
Kris, you want to start off on a couple?
Yeah, sure. So I think, as we start this discussion, it's when we're talking about heirs property, it's helpful to maybe define that. One of the things I found in a couple of decades of working with land issues, whether it's been kind of in a professional role of commercial real estate or volunteering with land conservation, is that really very few practitioners that I have interacted with whose livelihoods are land in some form or another actually have an awareness of heirs property. So it's often called one of the the worst problem you've never heard of, in particularly when talking about wealth and inequality in America. So heirs property, in some cases, is also called fractionated land, depending on the circumstance. It's land that has been passed down through generations without a will. And that has created, in essence, a shared ownership among all of the owners and descendants. And what that means, or it could actually be that there's been a will, and in South Carolina, it would have to be, if it hasn't been probated in 10 years, which is just the kind of the technical side of it, but then it would become kind of considered heirs property. So from a property law standpoint, it's a form of ownership that's as a tenant in common, which means if there are 10 owners, each owner has an undivided 1/10 interest in the whole tract. So if there's 40 acres, they each have a 1/10 ownership of the 40 acres. They don't own a specific 10th of the 40 acres, if that makes sense. And so the problem then arises where one of the 10, may want to sell, and that leads often to family disputes, among other things, that can result in court actions where one would file for what's called a partition, and a court could compel the others to pay the person for their interest, but unfortunately, a lot of the courts have tended to just force or compel a sale of the land, and that can, of course, eject property owners who live on the land. And we can talk more about the impacts of this, because it's a strategy of people who want to acquire this type of land, how they know that they can go after one of the heirs to be able to force a sale of the entire tract. But those are some different issues. And so I think it's just kind of heirs property and partition are two of the important concepts. As Diana mentioned, the Uniform Partition of Heirs Property Act is important just in the discussion, as that is being adopted. I believe it's up to 18 states now. South Carolina adopted it, and unfortunately, fortunately, it's been adopted there, but it's unfortunate that really the way it got pushed through was it was following the Charleston shooting massacre a few years ago, and it was named, the bill was really named after one of the victims, and so absent that incident, that tragedy, who knows if it would have passed as quickly as it did, but we're thankful it did. It has not been adopted in North Carolina. It has in Virginia, as Diana mentioned. But so that's kind of heirs property partition and Uniform Act. Diana, maybe talk a little bit then about land trust and conservation easements.
Sure. I just want to mention that the Center for Heirs Property Preservation, they frame this issue so nicely, where there's an issue about the creation of heirs property, which Kris just sort of went through the legal terms about the creation. Then there's the resolution. So we're talking about possible legislation, reform, mediation between family members, or written agreements, okay? But what the center does so nicely too is it takes it another step further. It goes, okay, well, if we have resolution, what is the sustainable use of the land going forward? How does that land remain in that family and in a sustainable fashion? And I love that third element of it. I think it's so smart. And I think that's where land trusts and the conservation movement really play an important part. What we do is we work with land trusts who are holders of conservation easements. Under law, an easement, a conservation easement, usually through state code, they're perpetual restrictions on land. And at first people are like, wait, restricting my land? That sounds foreign to what I would want. But the idea is that they are legal tools to preserve your land for the future, how you would want that land to be held in perpetuity. And so it's the legal restrictions in the document that then is recorded, and you have a holder of an easement, a land trust usually, or it can be a government agency. And they enforce that easement. They come and they monitor it on usually an annual basis, and ensure that those restrictions are being upheld. Some conservation easements also can be tax deductible. There's some great tax incentives both on a federal and a state level. So it's ensuring that land is conserved in perpetuity. And so that sustainable part, we see that role with land trusts working with family farms. We see them with timber, sustainable types of timber. Anyway, there's a variety of ways that land trusts can partner with families to ensure the sustainable use of that property going forward.
Okay. Just so I also have an understanding, in order to pass on or for someone to inherit land or for someone to give land, we have to establish ownership. And this is a part of property law, right? If I understand this correctly. And at a certain point, the government said, we're tired of people arguing over who owns what. There's going to be a title and a deed or something like this. Again, I make art, so I don't know about all this stuff, but there's
You're good. You're doing well.
There's an agreement or contract that says we've identified this amount of space or land, we surveyed it, and we've said that one person is an owner and they're allowed to sell it to another. In order to prove that, there's some document or there's some record kept somewhere. One of the issues you have is apparently following the end or the abolition of slavery, that people received lands, but they were either illiterate or had no means of documenting that ownership of land, or over time, some of that documentation has been lost, or people didn't even realize what they owned. Is that correct? Can you tell me a little bit about this?
You want to start, Kris?
Yeah, certainly. No, you're exactly right, Christoph. So, part of what we would say from our perspective is it's, clearing title. And what I would just take a step back and say, in this space when we're talking about heirs property, is my experience has been kind of to build what I had mentioned earlier about the lack of information or knowledge that people have on heirs issues. Is that I think then that leads to a lot of people having blind spots about their understanding of how other people use, access, and own land. And so when we're talking about this tenancy in common, you're right. The Sherman's Field Order 15 in Georgia and the Low Country of South Carolina and Georgia, where it was mentioned the 40 acres, and then the establishment of the Freedmen's Bureau to help shepherd through the granting of that land to the freed, formerly enslaved people. that immediately, if we want to go kind of in the history direction, it lost traction almost straight away. It never really took off, but there were enough African Americans who were able to acquire land. And what you then see over the generations is, to your point, it's how was the land titled to begin with. And so one of the barriers that we do have, and I think it's what makes this issue so in a way complex, is that you look at each individual state, and you have to look at their laws on real estate and titling, and really what one of the things that is a goal for addressing heirs property, and it goes back to the resolution bucket kind of that Diana had mentioned, is clearing title, and really what that means is, as long as so if we have a deceased person shown in the title records, and it doesn't matter if it's from 20, 30, 40, 50 years ago, for the current owners of the land to be able to avail themselves of certain benefits that we all have for those who are what's called fee simple owner. And that's what most people are who would seek to go out and get a mortgage to buy property or whatever. We take, I think, for granted that we can do that, whereas an heirs owner can't. So they have to go through this legal process of clearing title first, which involves getting with attorneys and oftentimes, looking through the family history, the family tree. So you get into a lot of issues there to try to then get the title and file the documents so that you can say that the current people who are residents and owners and users of that property are the ones who are legally the owners. And that matters for a variety of benefits, whether it's mortgage, whether it's insurance, whether it's disaster relief assistance following hurricanes. We see that as an increasing issue that disproportionately affects individuals who might have land but not, the clear title, for example. And it's actually, that's one of the things I think that's really nice about the work that the center and other organizations in the Sustainable Forestry and African American Land Retention Program are doing, is partnering with not just the forestry side to help generate a kind of income and the economic benefit, but it's trying to stabilize that land so that the current owners can use it. And then more easily pass it along to their heirs and others, but it's typically a complicated process, and so it's one that there's certainly a lot of need from within the legal community.
Complicated and expensive,
Yes.
unfortunately. Quiet title, if you think about the generations of documents that you need to search through, unfortunately, quiet title actions are expensive. I just want to comment too on Chris's great explanation that there is some current incentives too. The timing is pretty amazing right now, because the Farm Bill of 2018 authorized the United States Department of Agriculture to provide funds and work with states that had adopted heirs property reforms through the Uniform Heirs Partition Act. They're basically providing funds to work with heirs property landowners to provide the access to the services that Chris has just mentioned, and also to possibly provide funds to the states who have adopted the act to work with the landowners to quiet title as well. So it's a great opportunity. The details are still being worked out through the Farm Bill, but I did just want to mention that that is an amazing opportunity to work with heirs property owners. And those that do not have clear title, the USDA again is trying to work with those heirs property owners to figure out other agreements, non-traditional paperwork basically, that could allow those heirs to access services.
So if you had an individual where they received land where almost like via verbal contract, because theoretically verbal contracts are binding, correct? They're just like almost impossible to prove or legitimize. And so let's say there is this verbal contract of land or house being passed down, and it is challenged, and the people who challenge it are of African American descent and go to court, and there's a history of racism in that town or area. Is there a history of judgments going against folks that may have had legitimate claims due to literal lack of paperwork or literal lack of ability for them to fight for themselves?
Diana, do you want to comment on that?
I'm trying to think if there's a case that I could bring up and refer to under those. I'll start with that in order to show ownership of property, you have to have the deed or you have to have the will that, and it has to be recorded. Unfortunately, under traditional English common law, you have to have the will or the deed that's then recorded in the courthouse. The oral contracts, the oral promises when it comes to real property and in succession of property. If somebody has the deed, that's going to trump any type of oral contract.
And I would add, while not specific cases, I think you see, in dealing with heirs property owners long enough, there constantly are going to be references to the family land and things like that. And it's just, it's the land that the family uses, and they've been told X, Y, Z through time, but at the end of the day, as Diana says, you need an instrument, and that's really why that clearing of title is so critical. And really for organizations, particularly, that are in the legal space that help to help with those types of clear title actions.
And in addition, what we do see is an outside party, a non-family member, maybe approach one of the co-tenants, that joint ownership that we were talking about earlier. And maybe one of those co-tenants says, I'm moving away. I need to pay off some debts. I want to sell out. I don't want to be part of the communal ownership anymore. That co-tenant can sell his or her proportionate share to that outside party. And that outside party might have an ultimate goal of acquiring the entire property. And under tenants in common, that outside party who is now a co-tenant because they bought that fractional share can go to the courthouse and force a partition suit, a partition sale of the entire property. And so when we have the family with communal ownership working on that land, living on that land, and then to have an outside party be able to come in and buy a tiny portion of that property and then force the sale of the entire property, that's where we're also seeing the issues arise.
Okay. In terms of then protecting land, you'd mentioned a land trust. What is a land trust? I came across it slightly when we were looking at starting Black land ownership, and folks were like, yo, you should start a 501c3, or maybe if you want to lobby 501c4, and so I started looking up tax code, which you should never do. And there are like 17 different ways you can end up as tax exempt, whether it's starting a social club, starting a land trust, starting a 501c3. Can you explain what a land trust is for people?
Sure, I'll take a stab at it. Sure. So earlier we were talking about conservation easements, and the holder of a conservation easement, another entity that enforces the easement on the property. So a land trust tends to be a nonprofit, a charitable organization, so tax code, that is set up to promote, protect, and enforce those conservation easements, okay? So it is an organization with conservation expertise. If it's a tax deductible easement, then there are very specific requirements of the land trust to appropriately monitor and enforce that easement. And so that's determined by tax code. It's usually a corporation, a nonprofit, and then there are obviously some state code requirements as well.
Okay.
And I might add, if I can, that I think the holding and stewarding of conservation easements is generally, I think, thought of as the predominant mission of a land trust. But they can also, as a nonprofit, have in their mission being able to steward land and assist others in community-centered land, for example. That's in the discussions a lot more these days, because I think it recognizes that, again, going back to the discussion of a tenant or fee to actually place a conservation easement, for example, on heirs property land, could be a bit of an endeavor, because you actually have to, because it's a restriction that's placed against the title on the land, you have to have every owner agree to do it and sign off on it. And so, it might be easy if it's 2 or 4 owners, but think about, the typical heirs property scenario that may have, and I'm not going to say typical in terms of the number, but just the multiple owners. It could be 12, 24, 36, 48. I've heard through friends of mine in the space, that they've had properties that have had, 120 plus heirs. All of them have to agree to it. So, the deeper the history of the property and the more heirs there are, the more a conservation easement might not be able to be a primary focus as a tool for conservation of the land. That doesn't mean there isn't a role for land trusts in working with heirs owners to help steward and identify programs and others, such as sustainable forestry and agricultural practices that can still yield economic benefit to those landowners and help them steward their land. They just may not have the title restricted via a conservation easement.
Okay. And to try to give a frame of reference, for folks that don't know or do know, I think this kind of relates to this idea of, if you buy land, you have taxes on the land. There's always costs associated with the maintenance, the taxes, the upkeep. And so if you decide to purchase land that you can't live on and you don't want to do anything with, you want to just conserve, you'll end up just losing money on it. So with some of these land trust programs, it establishes an opportunity to maybe get government grants or to get funding to purposely not do anything with the land. I guess I'm trying to root that, like, if you look up and you're like, I'm going to just go buy 50 acres in Vermont, you go do that, you pay a lot of money for that, and then every year you owe the state money on that land, and if you don't do anything with it, are you just paying out of pocket? Well, if you're a person like me, I can't afford to just give the state $10,000 or $15,000 every year with no income being generated. But if I don't want to use the land, how do I generate income? Or how do I then cover those costs? So are some of these easements programs that assist in this, or can you give me a frame of reference there?
So easements can, if they meet certain criteria, properties can qualify for tax deductions. And those are determined by federal code as well. So you really have to look at each piece of property individually to understand its conservation values to determine if an easement would be appropriate, first of all, and if it would actually meet the federal code requirements. But in the scenario that you're proposing, if it's a specifically scenic piece of property, if there's specific habitat, so the code goes through open space, habitat, agricultural purposes are conservation values as well. So if you're actively farming the land, an easement is an amazing way to protect that land in perpetuity, but still allow production on that land. So I don't want you thinking that it just has to sit. An easement allows people to have a productive economy with that piece of property. You just have to identify the appropriate conservation values on that property, have that reflected in the easement, and then enforce it to make sure that those values are protected in perpetuity. So the conversation, a lot of family farms find conservation easements as a tool to keep them running, to keep them going, because yes, it does reduce the taxes, but it allows them to continue a livelihood that they love.
Right. Okay.
And I would just add to that, I think, one of the things you find in discussions, with property law, for example, there's this concept that's called there's a bundle of sticks that are what we consider of as the rights you have inherent in a piece of land and in a property. In some instances, if you unbundle those sticks of property rights, they can actually be more valuable unbundled than as they are all together. And where that comes into play is, if you think of the bundle altogether, is that's the example of a fee owner of land that just wants to sell the land, one time, or even rents it out for income. When you start unbundling it, though, you can have, say, again, if you have a tract of land, you can lease some of it to someone else to farm, to produce income. You can engage in sustainable forestry practices and generate income off of a portion of it that way. Of course, here in the Southeast, and particularly in the Low Country, you'll see heirs owners leasing out or licensing out some of that to for hunting rights, for example, because that's still done and practiced. But then increasingly, here in North Carolina and South, both Carolinas, and I'm sure Virginia and elsewhere, some of the discussions are, you have the current generation doesn't really want to remain in, say, for example, farming. And so what do they do with it? And if they don't want to lease the land out to someone else to farm, you see now a lot of that going to solar projects, because they require a lot of land, and generally you don't want to harvest all the trees, to create a clearing to put out the solar array. So you see those property owners. So there are multiple streams that you can set up. And of course, as it relates to agriculture, the U.S. Department of Agriculture actually has representatives in every county of every state in the United States. It's one of the few agencies people don't realize how far its reach is, and so the NRCS program it has can help property owners in that regard. And you have forest extension agents often through your land grant universities that can help, and I think that's a critical role, to be honest, that land trusts, that local land trusts can help heirs property owners with. And I should say, in this context, talking more about the rural heirs property, because there's also urban heirs property, right. But rural heir property. Because the land trusts are really plugged into the communities in terms of the kind of the funding sources or grant sources. They're plugged into the natural resource agency professionals that operate in those areas. They're plugged into generally the attorneys who are doing familiar with or doing some of that work, and appraisers, things along those lines. Because it's one of the things we've seen historically with heirs property is you might have someone come and offer a certain amount for timberland for the harvest of timber, for example, but they know, because it's an heirs owner, that they can undercut the value, and they might, who knows what their motives are, but I know that if you partner with folks like the land trusts and the local resource agencies, they can help guide you to the people who wouldn't perhaps try to undercut that and give you more fair market for that. But again, there are a lot of programs, and so I just wanted to say that. But I also did want to distinguish that heirs property exists in urban areas, and that's the issues with townhomes, brownstones, row houses, with gentrification, with tax sales, things along those lines that you've seen. That's certainly a valuable part of the discussion too.
So, just to add on, there's a book written by Andre Perry, who is a member of the Brookings Institute, called Know Your Price. I think his book deals mostly with more urban environments, but he talks about how the appraisal kind of structure has worked unfavorably against folks of African descent, and how people need to know the value of their own property because you'll see them basically get short sold on it. Then the bank that buys it, knows the actual value, sells and makes an immediate profit that should have been generated for the initial owner. And when we think about land, you all do know a lot more about this than I do, but maybe this kind of also relates in that you don't just own the land, their water rights, their mineral rights, their timber rights. Can you all, maybe Diana, can you discuss that a little bit?
Sure. So if we're talking more about rural properties and the resources that are on your property come with the land, basically. In the West, there are other complex laws about mineral rights and surface versus subsurface, which we don't need to get into today. But basically, the idea is the dirt you own comes with all the resources. Now, you can separate legally those sources from the land, and Chris was talking about some of them earlier, whether they be a license or a lease. There's a variety of legal tools. But those are your assets wrapped into the value of that land. And extracting those resources can be very profitable for some. There are ways to do it sustainably. And certainly, again, we talk as land trusts with landowners about sustainable ways to extract those resources. Or again, with conservation easements, some of those restrictions do prohibit certain types of resource extraction. They're valuable rights. As Chris was talking about that bundle of rights, those resources are part of that bundle.
Okay. In terms of what you all are working on, are either of you all excited about a current project or a certain endeavor or something you'd like to share with us? Somebody,
Yes?
you be excited. Go ahead, tell me, please.
I'm always excited about this work. Well, as I mentioned earlier about the curriculum that the Land Trust Alliance is putting together, it's wonderful that I get paid to read and to learn more about this issue. In fact, last night, for this podcast, I thought, I was going to just sort of look through some other resources, and the USDA has a really interesting review on what they call the Black Belt and heirs property issues, but it also brought in issues in Appalachia, as well as some of the indigenous and Native American tribes in the US, and some of the, again, constructive dispossession with those groups. And so in trying to accumulate some of this research for the Land Trust Alliance and this curriculum on the history of public and private land conservation, it just, every time I read something, it goes into a different direction or adds a layer or depth, as we were talking about earlier. So I'm just super excited to be a part of even figuring out what the questions are, what are the guardrails, because it can just become so not unwieldy, but so complex and so layered, because we just are going back to the beginning of sort of traditions that I certainly grew up in and learning about, but now learning about sort of the benefits of communal land ownership rather than individual land ownership. And the assumptions I've made are really somewhat being undone. And I like that process.
And Chris.
Yeah, no, so thanks. I think in terms of, if I had to say a project, I think it's just my journey in learning more on these issues. It's every time I read a book, it sends me off to multiple other books. It sends me down the path of history and learning history from primary and secondary sources, the history I never really learned in this context, and it can be very powerful. In terms of the project, I think it's probably, I'm extremely, I'm humbled to be able to serve on the Alliance's board, and I'm very humbled for my upcoming service with the Center for Heirs Properties board, because that's that's really bringing all of this together to help, to help families, and that's powerful. It's, most of my legal career, I went a different direction. I didn't go criminal law, family law, things that dealt with people, personal relationships. And yet I've ended up going in a direction now where it's all about it. And it's, how can I use my skills, talent, time to try to help people who historically have not had legal or political voices in any of this process. And so as I told individuals a couple of years ago, it's I'm a student just like y'all are, and as I learn more, what I've realized is learning. There's going to be a lifetime of learning, of reading, and all that, but that can't stop one from doing and taking action. And so to me, the taking action now, the opportunity that I can have to have these interactions with you and others, and help just talk about heirs property issues, get it out there. I'm very excited that heirs property issues are being discussed on much broader scale now than they have been, because it's always been a bit of an esoteric concept, because it's such a kind of a legal, it's a legal issue. But if you go into the communities where you have heirs owners, I mean, they know all about it from just their family side. They don't know the legal nuances of it. But so I just, I'm excited to talk to anyone about it, because I just think it's one of the biggest issues out there. People think a lot of these issues are issues of the past. The Pickford litigation here in North Carolina, that was a federal lawsuit, was settled in 2010 with a black farmer against the United States Department of Agriculture. It's the largest civil rights settlement in U.S. history. And yet most people don't realize that land is actually not only the largest civil rights settlement in U.S. history, but that it's as recent as 2010, and there are issues that are still ongoing that need to be addressed. So I think just to be whatever small role I can play, and if I can help educate folks that are in legal, corporate, conservation communities, then that's great.
Do you think young folks are encouraged as they're going through law school to enter this field or arena, or are they kind of pushed in other more prominent kind of sectors of law? And is there an opportunity for attorneys or lawyers to act as activists in this field?
Go ahead, Chris.
Okay, so certainly. I think that's actually, so whether younger ones are going in that direction or not, it's a great point. And it's actually one of the reasons that I've realized at this point in my career, one of the other roles I need to have is to try to help mentor, particularly first generation attorneys like myself, who don't come from a family of attorneys and have that background in their family. Because I think those are generally steered to big cities, big firms. And, the firms will in large part dictate a lot of what you do. Obviously, you have to have an interest in certain areas. But what we do find historically is that African-American attorneys who are entering into law school now are not going into kind of the wealth creation areas of law that one would think, such as real estate tax, trust and estates, wills, those types of areas, at the same rate, as they might be choosing other areas. So part of that is seeing faces in the community doing that specific work. As to opportunities for those, I think there are a variety of programs that center on wills type pro bono wills programs, which helps stem the growth and creation of heirs property. And so there are a lot of programs throughout various areas, rural and urban, that have wills projects. And for example, the Center for Heirs Property does, but there are others through legal aid groups and pro bono legal aid groups for attorneys to be able to help, in those areas. And that addresses one of the three aspects, which is maybe cutting off the issue from growing more, but it doesn't get to the more challenging issue of the clearing of the title, and that's something, that would be great to see folks getting more involved with too, if possible. I just think it's a challenging area, and I know from practitioners who have tried to do it, it's outside of, I think, some of the nonprofit models, it's hard to do that.
Okay, Okay.
And I know here in Virginia, there is a project currently being developed whereby when the reforms were enacted this past legislative session, the group of us said, okay, now what? We have the law, we have the reforms, but how does it help people on the ground? Yep. And so basically the Black Family Land Trust, again, got a group of attorneys together. They've opened it up through the local bar associations, and I think the Virginia Bar Association as well, to try and have lawyers join in as pro bono to work on heirs property issues. I think that the legal services, access to legal services, and at times a mistrust or distrust warranted at times of the legal community has been a true impediment in heirs property. And so trying to address that, and as an attorney, that is one thing that I can work on. And so in Virginia, again, they're trying to develop that project to make legal services accessible to owners of heirs property.
Has there been a history of attorneys being aware of these imbalances and using it to their advantage to purchase land or get into development, or not be advocates, but kind of contribute to this fractioning or issue?
Yes.
Okay.
Yeah, I mean, it's the showing up in a community saying, we're going to help you, sign here, to someone who hasn't had access to education, who can't read or write well, and their adopted signature is an X, and so they sign X, on a deed, and it conveys their right, all of their rights and interest in land. I mean, that's you see that in primary, and you see that in historical sources, certainly.
Okay. For folks that also aren't familiar, what are some of the ways? We mentioned a change in tax policy. We mentioned the fraction sale. We mentioned the kind of issues around heirs property. What are ways that people lose their land? Like, if I grew up kind of with this idea of, you have land, it's yours, you have it forever. The people can't tell you anything. And now that we're looking into buying land, it's like, oh no, the government can tell you a whole lot about what you do on your land, how it functions, things change. There's eminent domain. There are all these other elements to where it's not what I thought. So can you all give me a little information about that?
So I would just say on the eminent domain action, that's an interesting one, because one of the things you see with transportation and utilities is they actually don't have to worry about whether there's a clear title or not, because they have by authority, governmental authority, the ability to condemn the land. And so, there certainly are areas, communities that have been impacted by transportation and utility related projects that have, if you talk to people in the communities, it probably was heirs property. But they know that because it's heirs property, it's also, it goes to the valuation of it and what they have to pay out as the proceeds, because the ability to challenge it becomes a little more complicated with the number of owners involved. And so, look at some of the in the last, so many years, roadworks and utility expansions, and the chances are in certain areas you're going to see that it runs through heirs, what would have been deemed heirs property.
Okay. And Diana?
Yeah, condemnation and eminent domain are huge issues with large infrastructure projects. And I think we're starting to see much more press on how these routes for the large infrastructure are determined and what type of communities they are going through. Often large swaths of rural land that are not protected necessarily by conservation easements or other tools tend to be valued lower of their fair market value. And so it will be less expensive for these large infrastructure projects to go through those areas. And as Chris said, Those processes, those court actions for eminent domain are very specialized, and can be very quick too. You might get a letter one day saying that surveyors are coming onto your property tomorrow. And under state law, under certain state law, you can't bar them from coming onto that property. And so it's a huge issue about these large infrastructure projects and how those routes are determined and where they're going.
Wow. How would people know this stuff? Like how would any regular person that wants to have their, goat farm or grow their monk beans, how would and protect themselves in these scenarios?
So I think that is part of the role that easements can play. One of the things we also see with heirs property, I would say, is because it's a restriction on future use of the land, current and future use of the land, which could generally exclude certain types of development. When you're talking about certain families and individuals, who may not have the income, they may not want to restrict that right, for future generations or even for themselves, so if they could reach consensus on actually placing easements on there, whether they're agricultural easements or conservation easements, in terms of, clearing title goes a long way. Setting up a family LLC or a family trust, that is more clear. But again, that's a process you have to go through with attorneys, but that at least gets it under a single ownership. And that then the family members can have interest in that ownership, and you can set up the governance of that differently. But that at least makes it a little more clear, on clearing up of the title, and goes to some of the tax type issues that you can run into with tax sales, and some of the other, forced sale related issues that have occurred. Again, under the states that have adopted the Uniform Act, it's more of a challenge because that Uniform Act puts in a right of first refusal, in essence, for the other heirs to be able to buy at fair market value the interest. But in states like North Carolina that don't have it adopted yet, someone, a speculator can still come along and pick off an interest from a cousin in New York and compel its, through a partition action. So those are, I don't know if, Diana, you may have some additional thoughts on that.
No, I agree. I think local land trusts are incredible community resources. They have their ear to the ground about challenges or threats to the area, about changes in tax code, and their role is really, whether there are easements on the property or not, is really about the conservation of the land in that area. And so I really do think that they are there as a resource for that community.
And I would add, Christoph, just to Diana's point in terms of land trust, I think one of the values of the Alliance is, in some of the work that Diana and others with the Alliance are doing, is that this is information that we'll be able to pass along to, the over 1,000 member land trusts of the Alliance, so that a lot of this type of material is disseminated down to local levels, because there might be, local land trusts who aren't aware of some of these issues. I mean, one of the common responses I've heard is, well, we don't have heirs property in New York, and yet New York passed the Uniform Act because there is heirs property. There's heirs property anywhere. I mean, it doesn't take, you can just own a piece of land with a sibling, and that's heirs property, depending on the way you own it. So, but I think that can prove to be a very valuable resource, as this issue gains more and more attention.
And before we head out, can you all let us know how to reach your organization, how to reach y'all, the best way to get information? Because I want to make sure that folks have some actionable items like they can leave with, where they know, like, they have questions, they can look up certain groups or individuals or institutions, and hopefully take a lot of this information we've shared and be able to do something with it that's useful.
Sure, I am happy to talk about this issue and more. You can always reach me through the Land Trust Alliance. Just Google Land Trust Alliance, it's lta.org. Again, I'm Diana Norris. I think there are a lot of amazing groups out there that who have really taken the lead on this issue, and I continue to learn from them, and I want to make sure that they really get the applause that they deserve in this outgoing issue. The Black Family Land Trust and certainly the Center for Heirs Property Preservation and the groups that have been involved. So I would say definitely check out those organizations. I'd also say that the U.S. Department of Agriculture has quite a bit of information on heirs property and on the programs that they are currently developing and working on too. So certainly looking up the USDA and heirs property, simple Google search, but definitely Diana Norris at the Land Trust Alliance. I'd be happy to talk to anyone about this issue.
Awesome.
Yeah, and so for me, so my role with both the Alliance and the Center as board, it's a little more of a challenge, but certainly if folks reached out to you and wanted to interact with me, I'm more than willing, because I love talking about the issue. And I would add, of course, in addition to the organizations that Diana mentioned in North Carolina, is the Land Loss Prevention Project in Durham. And they are involved in a lot of these issues in the Triangle area of North Carolina. And in addition, there's the American Forest Foundation. They actually have the Sustainable Forestry and African American Land Retention Project. And that's Mavis Gregg is involved with that. And the center is actually the South Carolina location for the SFLR, as it's called, program. The Black Family Land Trust is the Virginia location for it. And actually the Roanoke Electric Cooperative in North Carolina is the program for it. But it actually stretches all the way over to Texas. So the AFF's Sustainable Forestry and African American Land Retention program goes from Virginia to Texas. And so there are sites in each of those states. I think it's up to 8 now. And as I said, the Center for Heirs Property is the South Carolina one, Land Loss Prevention Project is the North Carolina one, and the Black Family Land Trust is Virginia one. Those are all wealths of information. The Georgia Heirs Property Law Center, I believe, is the one in Georgia. So, there's a lot of material out there, and whatever certainly we can do, to help, we certainly will.
The variety of levels to this, and that like each municipality has kind of different code, each state has different code. So I would encourage people to check out the organizations that are, I guess, local or germane to their geographic area. A question that's a bit more like personal for you all. When I started speaking to folks about collective land ownership, especially attorneys, like when I spoke to regular friends, they were like, yeah, groups of folks had communes back however long ago. People in different cultures have owned land collectively for thousands of years. Every time I spoke to an attorney and said, hey, a group of my artist friends and people that are in relationships want to buy land, the first thing they say is do not buy land with multiple people. Have as few people involved in the ownership as possible. And then I find out about real estate investment trusts where you have to have 100 people involved. Or I find out about, these collective ownership organizations. And then I find out about land trusts where it may be 5 different entities that are involved, that are in multiple countries, what have you. Why are people so discouraged from collective ownership, but then you see collective ownership happening?
I can take a quick stab, which is, I think from an attorney standpoint, it's, because you see the issues of tenants in common, and partition actions and what it can look like when it goes bad. What I would say is there are ways, for example, setting up, maybe not in the context you mentioned, a family trust, but you could certainly set up an LLC where it makes it much easier. You can define the rights of each party who owns an interest in that land. You can set up all the governance of how you want that to run. And it doesn't require, for example, 100% of the owners to have to agree to everything, because that's where some of the disputes and personality differences can come into play. If you own it, as tenants in common, you have to have that unanimous consent. And so all it takes is one dispute for one person to fall out of favor with another, and you lose your ability to get that 100% if you need decisions made related to the land. So, you know, for example, if you set it up under an LLC, you might be able to have that it's a 75% vote. You know, so if you've had some who, you know, who are on the outs, for example, you know, you can still run the land, so to speak, what needs to be done, the business of the land or whatever, but not with quite the higher threshold of a tenant in common.
Yeah, I'll just chime in on that one, that as Chris mentioned, we tend to clean up at the afterwards when things don't go necessarily the way you might have intended them to. So I would just say that there are a lot of creative tools out there. The legal profession is, it takes time to change, but there are creative tools. Getting it set up correctly on the front end and documenting all of it will save you at the end. And so, as Chris said, the documentation and the right entity to allow that communal ownership is possible, but just doing it correctly and in a way that the law recognizes will help you enormously.
It's possibly one of the reasons that individuals are discouraged, because the amount of legal work and the costs associated to do it properly, and that it most likely won't be done properly. Because when you look at these huge development companies, when they engage in certain projects, it's multiple companies involved. There might be more than 5-7 different owners or what have you. Again, is it just that they have the resources to make sure it's structured properly, or what do you think the difference is? Like after a certain point, individuals don't have the capital to do certain things. And it is groups of people that work in concert as corporations. But then why, when, you know, my friends are trying to do that and to possibly build some type of wealth, are we discouraged?
I think it's the transaction cost is an element, right? I think there aren't as many attorneys. You know, again, I think when we're talking about the tenants in common and other forms of ownership of land, you know, it's glossed over in law school. You know, I mean, and really, if you're a practitioner involved in real estate, it's just not the type of ownership that you typically see. It's you know, I mean, and that's why I think there's such an education component involved with the heirs property discussion, because it's just making people aware this isn't a legal theory out there. This is the real world. You know, it's just you've not interacted with it to know it exists or whatever. And so, but I think the transaction costs can be an impediment, you know, to many, particularly for individuals or families or groups who might be land rich but cash poor, you know, because again, you can't access a lot of the programs that could help. You know, developers often set up, for example, multiple entities for tax and other purposes, tax liability, other purposes. They're setting, you know, for example, a development up under one entity that goes maybe to another entity that might go to a real estate trust or to their main headquarters, you know, their main corporate entity. You see that all the time as tax and corporate planning.
Okay.
What I would just say, though, is that the upfront costs to have a tenants in common agreement or a family trust or an LLC created is well worth the cost upfront, because the back end, when there might be trouble or you actually lose the property in the end, the upfront costs outweigh what could happen later on.
Yeah, we were advised if we were going to purchase property that we weren't living on and that would have any commercial purpose, to do so under LLC and remove our liability. And the person was like, you're going to have to start a company for every plot of land you purchase. And I was like, wait, so every time we want to buy something, we're going to have to spend thousands of dollars to then go spend tens of thousands, if not more, thousands of dollars. And they were like, yeah. And like totally nonchalant, like, of course. And you'll end up with 10 different companies and they all manage different property, because you don't want someone to sue you and be able to take all 10 of your properties that are under your one name. You want to have 10 different entities that exist in isolation. And I was like, wow, there's a whole world out here. I know.
It's a litigious
Yes,
world.
yes, it's
Sorry.
litigious, and unfortunately, attorneys, we're trained to think of what happens, if it goes badly, if it
Right.
goes wrong, on the back end. It's not everybody entering into something is generally positive and happy when they're entering into buying land or whatever, but it's the years down the line, if there's a disagreement and what happens, that's the eventuality that you'll hear individuals wanting to plan for and talk about.
Yeah. All right. Well, I want to thank you all for coming on. Again, this has been Just for My People. Would you all like to give your brief outros and then we'll say goodbye?
Just thank you so much for this opportunity. I really enjoyed talking to both of you. And again, I'm available if I can help in any way. So thank you.
Thank you. Chris?
Yeah, thanks for the privilege of talking about this. As folks know, it's something that I can probably talk about too much sometimes to some people, but I really appreciate the opportunity to share the time with both of you, and look forward to future discussions and continuing the dialogue.
Thank you. And we had spoken before where I mentioned I grew up in the DC area, so shout out to the DMV area. And I actually used to spend every summer down in North Carolina along Tobacco Row. A friend of the family had a farm, and I'd go out and I learned, don't name the goat because it might not be there the next year. Don't give the crabs. The animals aren't pets. So yeah, I want to thank you all. And again, this has been Just for My People. My name is Chris Carr, and we are signing off.
Thank you, Chris.